no on this legislation. Thank you.
And is it Dr. Snowden?
No, no doctor.
No doctor.
Just call me Dane.
Okay. Well, Dane, any questions for Mr. Snowden? And Representative Hinck.
Thank you, Mr. Chair. You're welcome, Mr. Snowden. Appreciate your coming here, even if you were well paid to do so.
I question the well-paid part, but I am paid to be here.
I can pretty much guarantee that as between your position and behind this horseshoe, you're well paid. My question is about the Motorola warnings. Can you discuss those in more detail? Why are they there?
Well, I need to look, I don't know exactly what she's referring to, but I'd be happy to take a look at that and get back to you. But a lot of the information we have in our manuals is because of the OET Bulletin 65C, which is page 41. It explains exactly what carriers should put in there to explain to consumers how they comply with the law.
So you don't understand that Motorola has a different warning than other companies?
Well, I would say it's not a warning first. I would say that their
advisory.
Well, their compliance statement might be different. I think all of the carriers, the FCC gives them judgment. If you actually, we'll submit to you the OET bulletin, which goes through exactly how they say. And they say, for example, I'll read it to you. So the following are examples of typical statements that provide end users with necessary information about body-worn accessories. So that's what the OET, I'm reading from the OET bulletin. That goes through, and then it gives you examples of how you should state your compliance with that standard.
Did any of those OET recommended possible phrases match up with what we heard in testimony?
I would need to read exactly what she's referring to, and if she's willing to provide a copy to me later on, I'll be happy to get back to you during the working session.
So in the work that you've done on this, you haven't had that issue come up previously?
Not the Motorola example, no. I think last year they brought up the Apple example.
Is it conceivable that Motorola thinks that providing language like that would be helpful in the event that later on some legal matter arose and they could mitigate or lessen their exposure to liability?
Again, without seeing the exact document, I'm not going to comment on what Motorola's motives are or even what the document says, because I have not read it, but I'm happy to look at it and get back.
One other question I'd have on anything that companies might put that sounds like warnings to people, but you're saying they're not warnings, advisories or consultation or any of that language, could they use it themselves? Is there language that a company could use themselves that a state could not require?
I'm not sure if I follow exactly where you're going.
I'm positing that anything that a company could say themselves, we could require them to say. Is there a reason why we could not?
Well, I don't know. I'm not a lawyer, but I can tell you I don't think the government can compel speech constitutionally.
So warning labels of any kind you think are unconstitutional?
Well, if you're compelling speech, yes.
So have you brought that challenge over the cigarette warnings? If you won that case, you could get quite a bit of...
I don't smoke, I don't advise smoking, and I have nothing to do with that industry.
But it sounds to me as though you think the warning labels on cigarettes are compelled, unconstitutional, compelled.
I have no comment on what tobacco's doing.
No, I'm not talking about tobacco. I'm talking about government requiring warning labels on tobacco.
I'm not sure.
I'm not sure if that's germane to me, because I don't represent them, and I'm not going to comment on what that industry might do or might not do.
Mr. Chair, I need to clarify this.
Yes, with your indulgence. Certainly.
I thought I understood you to say that government could not require warning labels because that's compelled speech.
I'll restate it again. We feel, and we saw the situation in California actually, that when government compels us to speech, we think that's unconstitutional.
So how is that different from what I said? Do you think...
I'm just stating it in my words, so if it's not different, I think maybe we're agreeing with one another.
Yeah, maybe we're agreeing with each other. Do you have an opinion about whether the state of Maine could require, if a product is sold in the state of Maine, that it have some language constituting a warning on its package?
If you're barring us from being able to enter into the market, the Telecommunications Act, Communications Act forbids that, and that's about entry. and that's Communications Act of 93. On the 96. On the 93 Act of the Telecommunications Act, Communications Acts are different than Telecommunications Act, sound similar but they're different. That actually bars states from getting involved on the RF issue specifically. So on those grounds, you have two acts that say, yes, you are barred from that.
Now you've raised a second issue.
Okay?
Have you left the first one behind?
No.
The first one you said was unconstitutional compelled speech.
Well, compelling speech but government can't compel speech.
So my hypothetical was, if a company wants to sell a product, a widget, in Maine, can Maine require that certain language be on the product label before it's sold in Maine?
Are you giving specific language?
Yes.
Then I believe that is unconstitutional. You can have actually, I would recommend we can solve this by having your Attorney General look at it.
However, we do have an example in which the federal government has required warnings on cigarettes. You don't have to know anything about cigarettes to evaluate whether or not that's unconstitutional compelled speech in your view, similar to what you're saying cannot be done here.
I've actually answered already on what our opinion is on this matter as it relates to wireless. I don't know what more I can share with you other than I can't comment on what the tobacco issue is.
I was trying to understand what it was that you thought we couldn't do as a state, and I haven't been able to understand that.
I will do my best to state it one more time. I believe if you're compelling speech, that is unconstitutional.
And then to understand what you said, I had an example.
Right.
And you won't comment on that example.
I don't represent that industry, sir, so I don't know all the ins and outs of what happened there.
It's not the ins and outs of that, it's whether that label on the tobacco package is
I have
unconstitutional.
an easy way to solve this when we ask your Attorney General.
I'm not going to ask my Attorney General
Okay.
to clarify what you said.
Wait, do you agree or disagree then? I will stand what I said, but I'll go from there.
Representative DeHoo.
Thank you, Mr. Chair. It's just a question maybe you can clarify in San Francisco when it's in the court systems, if I'm not mistaken.
Correct.
And the reason that is because?
Because we found it unconstitutional about what they're doing. And they're trying to require speech on a warning label. And we found that it was, we felt, and we filed a suit saying that that's compelled speech, and we're suing them over that and a couple other things. And right now, as we understand it, that piece of legislation was supposed to go into effect maybe a year or so ago, and it's been delayed and delayed and delayed. And recently we heard from the city attorney that they are further delaying it so they can regroup with the city council.